How often would you say people who are considering divorce or suspect it is coming meet with an attorney before they make the decision or the decision is made for them?
I mean, sometimes that's hard for me to assess as a divorce attorney, just because I don't necessarily know what's been going on in their lives before they hit my office. Um, my sense, though, is that they would much more often than not meet with an attorney when they're ready to file, which sometimes is fine, but sometimes it's not so fine. Sometimes damage is already done in their case by the time they come in to their attorney. I can give several different examples on that. I had one case where a client had retained me for a custody case a while ago. We finished it up with a settlement. In between times, she was essentially representing herself, didn't bother coming in for a consultation or to retain me as her attorney, and decided to continue to call in what the court is eventually going to deem false allegations of child abuse or child neglect, and then filed what will turn out to be a defective modification petition to modify her custody settlement that had just been done about a month prior. Now, if she had come in to see me prior to actually taking those actions, I probably would have walked her through, hey, look, does this really seem like something that's going to be corroborated by CPS? And is this really something where you want to, go running back into court? I would have preferred first to hear a medical opinion from a doctor saying, yeah, I saw marks or bruises on this child, and those marks or bruises that I saw as a physician are consistent with child abuse or child neglect. If you have that, then in my mind, you have something. If you don't have that, merely seeing marks or bruises on your child, even when the child was with the other parent, and even if the child says the other parent did this, if you don't have the medical proof to back that up, it's going to be a problem if the child is only saying that to you, but then not saying that to police officers, CPS investigators, et cetera, because then you're essentially saying, well, gee, the child's reporting child abuse to me, and I'm seeing marks on the child. So wasn't that the basis for supervised visitation on the part of the other parent? And my answer would be, no, not necessarily. Because again, you come back to square one, which is, did a doctor say they agree that the marks or bruises were consistent with child abuse or child neglect before you went to the process of calling CPS? It becomes a problem, and that's an instance where somebody has essentially come into an attorney after the fact, after they've already done damage potentially to their own case. I have another example where a client came in, consulted me on a divorce matter. The parties had just sold a co-op. I think the equity that they got was about $250,000. And I advised them, look, if you've reached that point where you want to terminate the marriage, let's go ahead, file the divorce, get it in the pipeline. Now, in New York State, when you file a divorce, the key thing is that it puts into place automatic orders saying that neither party can transfer money out of accounts or close accounts, et cetera, except in the usual course of business. Certainly, they can't touch retirement accounts at all. And this guy, instead of following my advice, waited at least a year, but I want to say it was probably closer to 2 years before then coming back to me, hiring me as his divorce attorney, and then saying, oh, by the way, all that money that was in the joint account, my wife went in and raided the account and now has $250,000 sitting in her account, and I have nothing in mine. And the problem is he's already done damage to his own case because we went in front of the divorce judge, and the divorce judge says, I hear what you're saying, Mr. Bliven, and that's a good argument for trial. I'm not going to order the wife to restore the funds at this point to the joint account or split that account with your client. And then the problem for his case is his wife had $250,000 to spend on divorce attorneys, and he had nothing to spend on divorce attorneys. And so her divorce attorney eventually just papered us to death. And eventually he had to release me and agree to a settlement that was vastly different than he would have gotten had he been able to continue to retain any attorney, let alone me. But there's many other examples. I had another client who, rather than coming into an attorney when you could see your marriage is definitely going downhill, it's heading for a divorce, that's probably the time when you want to have that consultation with a divorce attorney, just to say, hey, look, here's the asset and property issues, here's the potential custody and access issues that are going to be involved. What do you think as my potential divorce attorney? Well, this client, instead of going into a divorce attorney, he made a number of damning threats and accusations toward his soon-to-be ex-wife that she then reported. And they were really bad threats, like threats of, if you keep on, I'm going to get the chainsaw out and cut you in half, and he tried to later explain it in the divorce case and say, well, I didn't mean that literally. It was just my morbid sense of humor, and I was going through extreme depression, and this is how the sense of humor came out, and I admit it was completely wrong to joke in that way or attempt to joke in that way. But the fact remains, the wife had all those audios transcribed and threw them into a motion with the judge and said, Judge, take a look at all these threats. Now I want an order of protection and supervised visits. And the judge granted that just immediately, putting him vastly behind the eight ball in any custody or access litigation. So, I would say if you see your marriage clearly heading for divorce, there's no realistic odds that the marriage is going to be salvageable either through counseling or going to a priest, pastor, rabbi, etc. Have that consultation now. Even if you're not planning on filing for divorce in another year or two, you want to have that consultation now so that you can prepare for that eventual filing.